Now, I want to talk specifically about inducement matters, and that is that the hurdle that must be cleared by the department for us to assert a violation in the FEL program is a quid pro quo relationship between the awarding of a particular loan and the crews of New York Harbor, for example. So that I must prove a direct relationship between that act and the awarding of the loan. And that is why we need changes in the law.
But with all due respect, the question of whether you can prove that or not, and your understanding, and apparently a lot of other people's understanding as they prosecuted this, is to, at a minimum, its ethical unacceptability. The idea that if you couldn't prove it there, you know, you sort of, we won't get into the other parts, that therefore no action is taken. We're going to monitor it. On all of the monitoring over 5 years, you couldn't make a determination as a department that these practices should have been stopped. These practices people were laying out millions of dollars of these inducements. I appreciate that there's not a piece of paper between the University of Indiana and $3 million grant from Sallie Mae, and they drive this direct student loan program, a federal program, off campus. But you know when they were caught at it? They pledged to never do it again and pay back the money. You know when these other people were caught at the cruises and it was brought to light? They paid back the money. They rebated money to students. They swore they would never do it again. So none of that was about proving it in a court of law. People were caught and the officials showed up at their front door and said, this practice is unethical and illegal. They didn't say, well, take me to the Supreme Court. They were caught. But nobody from the Department of Education showed up at the front door. That's what I don't understand.
And I guess my question would be, did anyone show up from the FTC or the SEC or these other bodies?
They're not here today, with all due respect.
Well, Mr. Chairman,
this is about your program. This is about, because your program is coupled with, you can't suggest that this is laid off on the private loan side. This is coupled with the very same parties. It's convenient to decouple them, but the fact of the matter is Sallie Mae was offering private pools of money in exchange for an increased federal participation in the loan volume. They were coupled.
Mr. Chairman.
And when they were caught, Madam Chairman, when it was suggested that we understood what they're doing, they said they'll never do it again. Other lenders had brought this to the attention of the department.
I agree with you that we need changes in the law to make it more robust with respect to enforcement.
What went wrong?
Mr. Chairman, as you know, and as I've pointed out on this diagram, there are 6,000 institutions. This is a multi-billion-dollar industry. There are aspects that relate to eligibilities and authorities governing the FEL program, and others that relate to FEL. There are multiple grant programs.
When it was suggested that students would not get a loan they applied for because it was not the lender that the school chose, you issued a dear colleague. Boom, you stopped the practice.
And I have the authority to do that under current law.
For paying people, for putting people on their payroll, for providing trips and inducements, for exchanging, taking the federal program off campus for money. There's no dear colleague, there's no letter, there's no phone call that the department, the director of the program, whoever can make to say this is unacceptable?
We have conducted thousands and thousands of audits of programs over the last several years, obviously.
But apparently not related to this.
Well, to the extent that the law, that I'm charged with implementing a law and enforcing a law that has a very high hurdle to be cleared, then, you know, perhaps we need a change in the law.
With all due respect, I cannot accept that answer, because it isn't about the high hurdle to be cleared. It's about whether or not you look at a situation, and again, mind you, other law enforcement agents have looked at the situation, made a determination, and the practice ended. Nobody went to the Supreme Court. Nobody went over the high hurdle. It was clear on its face the egregious nature of the inducement, the conflict of interest, and the unethical behavior. Nowhere in 5 years of monitoring, which was the department's accepted practice, did anybody make an effort to call a halt to these practices, with all of the audits that you cite in your testimony.
Well, as I said, We monitor these programs vigilantly. There are
Apparently
thousands.
not, Madam Secretary. I understand what you're saying, and that's what you told the Inspector General, that your choice of enforcement was continued monitoring. Who was monitoring? What, I mean, did they have blinders on?
Thousands of audits and
Not with
oversight.
respect to this problem. I know you have audits and people have paid money and you found problems with the programs all over
fines,
campus.
and
you never found one of these problems, apparently.
well, to the extent that it was not a violation of the laws, whether I'm charged with overseeing, then no, we didn't.
But you
take
made an
action,
assumption. You made an assumption that whether you put people on a cruise to the Caribbean, whether you pay millions of dollars to kick a federal program off campus, whether you provide private money so you can buy a larger share of the federal loan program on a particular campus, you made a decision at the outset that none of that was a violation of the law. And it was not worthy of any discussion with a campus, with a college president, with a lending authority, or with the loan officer on campus.
Clearly, I was concerned about those practices, and that's why I initiated a rulemaking last fall. But I would say that the ability to try to prove that level of legal burden in such cases was not something that...
I'm afraid that's become a crutch. That's sort of like you said, it's a high burden on Nelnet, so therefore we'll let them keep the $300 million and we won't go out and they'll give up the other. They gave up $1 billion and you said this was too high a burden to think about going to court, and the minute you walked in the door, they gave up $1 billion.
Mr. Chairman,
they must have had a hell of a strong case. They must have said, boy, we got them, we got that Department of Education nailed. We got them so nailed, we're going to give up $1 billion.
well, I was
not plausible.